And Paul, I'm going to shut up now and I'm going to give you the floor.
Good morning, everybody. As Dwight said, I'm going to talk about copyright, which is the foundation of everything. Lawyers,
Important. Take notes.
writers and artists and creators as intellectual property, property that's created from the brain rather than real property, which is land. So we're going to talk about one of the three aspects of intellectual property, which is copyright. The others are trademark and patent. Patent protects inventions, trademarks protects the names of goods and services, and copyright protects original works of authorship. And I'll explain each of those words except the word of, because of, I think we can all understand. But the word original, the word work, and the word authorship are all extremely important. Before I get started, yes, everybody has muted themselves. If you want to ask a question, I will see that you have unmuted yourself, and therefore I will stop talking and call on you, as it were, if you unmute yourself to ask a question. And please do that rather than waiting for the end, because as Dwight said, there will be no end. I'll keep talking until I have to go. Okay. So as I said, copyright is the foundation on which everything that you do is built. And it protects original works of authorship. So original means original in two senses of the word. It means original in the sense that it originates with you. You are the creator. You are the owner of the copyright in whatever it is that you have created, whether it's a painting, whether it's a musical composition, whether it's a drawing, whether it's something you've written, whether it's something you've filmed, whether it's a photograph that you've taken of something. You are the owner, you are the originator of the copyright in that work. Original also means that it has some element of originality, some element of novelty and originality, which means that, for example, you could not, copyright would not protect a phone book, a list of names and phone numbers. Copyright would not protect a grocery list or something as simple as that. Even though, yes, it's written, it's not original in that sense. So original in the sense of it originates with you, and original in the sense that it has some element of originality. Work. A work is something, and this is the words of the Copyright Act, so please forgive me, that is fixed in a tangible medium of expression. Fixed in a tangible medium of expression, which means in English that you can perceive it with your senses. You can hear it, you can read it, you can watch it on a screen. Whatever that it is fixed so that you can perceive it with your senses. I'll give you an example of something that wasn't until fairly recently protected by copyright because it was not fixed in a tangible medium of expression, and that is choreography. Until fairly recently, I'm told, there was no way to record the same way you record musical notes on a page, quarter notes and half notes and keys and all of that on a musical staff. There was no way to record or to fix the choreography in a given dance. So, but now there's some system of notation like musical notes to fix copyright, and therefore choreography. And therefore, choreography is now something that is protected by copyright because it is fixed in a tangible medium of expression. So original works of authorship, which means that you, as the author of the work, the thing you've written, the drawing you've drawn, the graphic that you've created using your computer, whatever it may be, you are the owner of the copyright in that work. Now, unlike trademark and unlike patent, where you have to apply to the government, and the government issues you a certificate in whatever it is that you want to protect, your trademark or your patent, or certificate of ownership or certificate of registration, you have a copyright in your work at the moment of its creation. The moment you put words down on a page, whether it's via a keyboard or via a pen and paper, or dictate them or whatever, the moment you put down words on a page, the moment you put paintbrush to canvas, the moment you put knife to clay to create a sculpture, the moment you start composing a musical composition, you have a copyright in your work. The words of the statute are, copyright inheres, is inherent in a work at the moment of its creation. So when people say, I have copyrighted my work, they are misstating what has happened. Copyright is never, ever, ever a verb. One does not copyright as in do something, a work. One can register a copyright in a work, which I'll talk about in a few minutes, but you have a copyright in your work the moment you create it. My old boss at the very first law firm that I worked for used to call copyright the greatest piece of self-help legislation ever enacted by Congress, because you don't have to do anything in order to own what you've created. Unlike real property, unlike your land where you have to record a deed and all of that, and it has to be in writing, unlike like I said, a trademark or a patent or virtually anything else in this world, Congress back in the 1870s was smart enough to recognize that works of authorship needed to be protected as soon as they were created. And that's why copyright inheres in a work at the moment of its creation. Okay, I said I would talk about registration of copyright. So, in order to be able to sue for copyright infringement and collect a couple of benefits of the Copyright Act, which I'll talk about in a minute, but in order to be able to make a claim that somebody has ripped you off, has infringed your work, you must register the work prior to the date of infringement. And so, as a practical matter, what you want to do is register your work for copyright when it leaves your own hot little hands. When you send your work out into the world, when you're trying to get yourself an agent to sell your book, when you're sending a graphic to someone to reproduce, whenever you're sending the work out, it goes out from your computer or goes out from your home physically, or however it's being sent out into the world, that's the point where you want to register your work for copyright, just in case the recipient of that work rips you off. Obviously, I always tell clients, lawyers get paid to do two things in this world. You anticipate the best thing that can happen, and you anticipate the worst thing that can happen, and you deal with both of them now. So the worst thing that could happen is you send your work out into the world and somebody rips you off. And if that happens, by registering your work for copyright, you're able to file a lawsuit for copyright infringement to vindicate your rights and recover your damages. But if that's not enough, the Copyright Act provides for two huge incentives to register your work, in addition to being able to actually file a lawsuit, which are what are called statutory damages, damages recoverable under the statute, and attorney's fees. So let me talk about statutory damages first. At the end of the day, our court system can only give you money. A judge or a jury can only give you a judgment where it says defendant shall pay plaintiff X dollars. They can't give you your work back. They can't unring the bell and create a situation where you never got ripped off in the first place. All the legal system can do is compensate you for damages and give you an award of X dollars. So Congress recognized a long time ago that for a beginning writer especially, or a beginning artist or composer or whomever, it is very difficult to quantify how much you've been damaged by when somebody rips off your work or infringes your copyright. And therefore, instead of having to prove your quote-unquote actual damages, you can recover, if you have registered your work for copyright prior to the date of infringement, you can recover statutory damages, not tied to the actual damages you have incurred, but instead tied to how egregious the infringement has been. So statutory damages can range from a minimum of $150 to a maximum of $150,000. So if there has been what's called willful, deliberate, knowing infringement, somebody has made counterfeit copies of your CD or of your DVD. Willful, deliberate, knowing infringement, damages are $150,000. Almost certainly that's what the judge will award you. If, on the other hand, there has been innocent infringement, the damages could be as little as $150. Let me give you a quick example of what innocent infringement is. Everybody well, we're all old enough to remember the Beatles. We're all old enough to remember George Harrison. And George Harrison wrote a song called My Sweet Lord. I promise, by the way, I will not sing because I am a terrible singer. However, the three notes in My Sweet Lord are identical to the three notes in a song by the Isley Brothers called He's So Fine. So when George Harrison came out with My Sweet Lord, the Isley Brothers sued him, saying that he had ripped off the melody, the three notes, and therefore My Sweet Lord infringed the copyright in He's So Fine. The jury found that yes, those three notes were identical, and therefore there was technically copyright infringement, but Harrison had testified that he did not deliberately sit down and decide, I'm going to rip off He's So Fine when I'm writing My Sweet Lord. He simply knew that song as well as hundreds of thousands of other songs, including, of course, Beatles songs, and innocently copied or used those same three notes as used those same three notes that were in He's So Fine in his musical composition, My Sweet Lord. And therefore, the jury said, yes, that infringement was innocent, and they awarded the Isley Brothers $150. So that's statutory damages. The other big benefit to registering your work for copyright prior to the date of infringement is the ability to recover attorney's fees from the infringer. So let me back up. Under our system of justice, when a plaintiff files a lawsuit against a defendant, the plaintiff pays his or her own lawyer, and the defendant pays his or her own lawyer. And regardless of who wins, who prevails in the lawsuit, each side pays their own lawyer. Now, that system, which by the way is unique to the United States, it is not the case in any other civil country that has our similar system of justice. It is not the case in England, for example. It is not the case in Canada. It's virtually nowhere else except the United States is our system where each side pays their own lawyer. Right? That's our system. So that can be varied by one of two things. It can be varied by a contract which says that in the event a lawsuit is brought to enforce the terms of the contract, excuse me, in the event that happens, the prevailing party, the winner of the lawsuit, will recover attorney's fees from the losing party, the non-prevailing party. So if there's a contract, for example, most residential leases, if you lease your apartment, will provide that if the landlord has to sue the tenant for not paying the rent, or the tenant has to sue the landlord for breach of the warranty of habitability, for example, the apartment is infested with bed bugs or rodents or, God forbid, whatever, and the tenant has to sue. If the tenant wins the lawsuit, in addition to getting damages, the tenant can recover the attorney's fees that the tenant has paid the lawyer to bring the lawsuit. So one of the ways that system, our system of justice, gets varied is by a contract. The other way is by a statute. And in this case, the Copyright Act provides that if you register your copyright prior to the date of infringement, and if you prevail in the lawsuit that you bring to sue someone for copyright infringement, in addition to the damages that have been awarded to you, you can also recover the reasonable attorney's fees that you've paid your lawyer to bring the lawsuit in the first place. Now, you must recognize that the converse is also true. If you sue somebody for copyright infringement and they win, they prevail, the jury finds that there was no infringement for whatever reason, or the judge finds that there was no infringement for whatever reason. And I'll talk about what it takes to make a claim for infringement in a little while. But if you lose that lawsuit, you will have to pay the defendant the attorney's fees the defendant has paid the lawyer to defend the defendant in that lawsuit. So it works both ways. That's only, by the way, under a fairly recent US Supreme Court case involving Creedence Clearwater Revival and John Fogerty, where his record label sued him for copyright infringement for infringing his own work. A bizarre lawsuit. He prevailed. He got Fantasy Records to pay him the considerable attorney's fees he incurred to defend himself in that lawsuit. This is a case that actually went up to the US Supreme Court. Okay, I'm going to stop for a second and ask if there are any questions about anything I've talked about up until now before I move on to the next thing.
Oh, yes, I got a
Once.
question. Hello, I got a
Please.
question. Hello?
Please.
Okay, so you talked about like a lot of copyrights and stuff. Like most of us are writers, and I'm trying to be one, like become a better writer too.
Mhm.
I want to know, how are parodies of characters not copyright, or how can you do it to make sure they're not copywriting?
Okay, what's a parody? Funny, I just had this discussion with my son last night. So here's an example of a parody. Parody has to refer to the original, for lack of a better word, source of the work. So you're too young, Arturo, but most of us remember Saturday Night Live, Eddie Murphy doing a parody of Mr. Rogers, right?
I don't remember that one, but I don't know. I
Okay.
might have to look that
So
up.
that's the classic example of a parody. Another parody was a comic book called Mickey Rat, which was a parody of Mickey Mouse. So the character drawn in Mickey Rat had the same little pair of shorts that Mickey Mouse wears, etc. So the clothing that the character wore was identical, but it was a rat, and it was, with the long snout of a rat instead of Mickey Mouse. But it was obvious that it was referring to or making fun of Mickey Mouse. That's a parody. That's protected by the First Amendment. So if you do a parody of something and the something owner of that something sues you for copyright infringement, you will prevail in that lawsuit if your work is indeed a parody of the source of the underlying work. Where this gets tricky is deciding, how subtle you can be. So, something like Eddie Murphy parodying Mr. Rogers, it was obvious. He did the same moves. He came down the stairs. He put on the sweater, all the classic things in the Mr. Rogers show. Mickey Rat, again, it was obvious that it was a parody of Mickey Mouse. I'll give you another example for those of us who are old enough to remember Edgar and Johnny Winter, the guitarist, the albino guitarist in the rock band in the 1970s. Somebody put out a comic book parodying them where they were snakes playing the guitar. But again, it was the Winter Snakes, or I forget what the thing was called, but it was a less than obvious parody of Edgar and Johnny Winter, but still on the scale of a parody. And there was a lawsuit, and the jury ended up finding that indeed, yes, it was a parody. Can I tell you, Arturo, that absolutely whatever it is that you're doing is going to be found to be a parody of whatever you're making fun of? I can't tell you that. If you want to consult with me privately and tell me exactly what it is that you're making fun of, I can give you my opinion. But at the end of the day, my opinion is as useful as anybody else's opinion. It's going to be up to the 12 members of the jury someday, somehow, if there's a lawsuit against you for making fun of whatever it is you're making fun of.
All right, thank you.
Okay.
What
Yeah,
about political cartoons?
Same idea.
Wow. Okay.
Yeah. First Amendment is a real strong defense, but it's got to be something that the First Amendment will protect, like a parody, like satire, political cartoons are obviously protected by the First Amendment. No, they don't infringe anything else. Even when the political cartoon uses either a real person in the cartoon as a drawing of the real person in the cartoon, or it uses a drawing of some other thing like Mickey Mouse in the political cartoon, that's all protected by the First Amendment and would be a complete defense for any claim of copyright infringement. Okay, let me talk about what it takes to make a claim for infringement. Copyright protects original works of authorship, like I said. The other way that lawyers talk about copyright is copyright protects the expression of an idea, but not, underline, not the idea itself. Let me give you an example. Boy meets girl, boy's parents and girl's parents do not want them to be together. The basic idea or the basic premise of Romeo and Juliet. We are all, maybe with Arturo and Henrietta accepted, we are all old enough to remember West Side Story, 1951. In West Side Story, boy meets girl, boy's parents and girl's parents do not want them to be together. The same basic idea of Romeo and Juliet. So let me ask a question by a show of hands. If William Shakespeare had written Romeo and Juliet in 1950, a year before West Side Story came out, and obviously William Shakespeare was alive in 1951 when West Side Story came out, could William Shakespeare have sued the makers of West Side Story for copyright infringement? How many people think yes? Donna, you think yes. Katina, yes? You thought yes? Okay. Arturo, you think yes. Okay. The answer is absolutely not. The only thing that was taken from Romeo and Juliet in West Side Story was the basic idea. Boy meets girl, boy's parents and girl's parents don't want them to get together. Everything else in the movie West Side Story and the play Romeo and Juliet is not the same. The characters' names, the dialogue, the setting, the time in which it's set, the conflict, besides the fact that the parents don't want them to get together, the conflict between Romeo and Juliet and the conflict between, I forget the names of the characters in West Side Story, but their conflict, none of that is the same. Not a line of dialogue, not a single character name, nothing is the same. My point is that copyright protects the expression of an idea, not the idea itself. Let me give you another example. Alien crash lands on Earth, and this is a real case that was brought in the 1970s or 80s. Alien crash lands on Earth and wants to go home. Loki from Maldemar was written by a woman in Oklahoma and sat in her drawer, because I think she typed it on a typewriter, sat in her drawer, and then one day she went to see the movie E.T. And she thought, I've been ripped off. My script, Loki from Maldemar, has been ripped off by Steven Spielberg and Kathleen Kennedy and Universal Pictures and everybody else who who made and released E.T. Not only did she lose because nothing in Loki from Maldemar, other than the basic idea of alien crash lands on Earth and wants to go home, nothing was taken, but she also lost on the other element that's essential in order to prove copyright infringement, and that is access. In order to prove copyright infringement, you have to show and prove that the infringer had access to your material, had the ability to copy it by having access to it. Now, in the first example I gave, my hypothesis was that Shakespeare's play had been written and produced and mounted on a stage prior to West Side Story being released. So the question of access was not an issue in the hypothetical example that I gave. But in the case of Loki from Maldemar versus E.T., that was a big issue, because the author of Loki from Maldemar, or the writer of Loki from Maldemar, obviously could not prove that anybody, let alone Steven Spielberg, Kathleen Kennedy, or anybody else involved in making E.T., had even heard of this woman, never mind had read her script. So her lawsuit failed on two bases: no access and no what is called substantial similarity. Not just a little bit similar, not just, the name of my lead character is the same of the lead character in the infringing work. Not just a little bit similar, not just somewhat similar, but substantially similar. That's the standard in order to prove copyright infringement: access and substantial similarity. The reason why very few cases are actually brought in court, or if they are brought, are never tried to the end to a jury, but settle, is because of this, and because the Copyright Act provides for some unique remedies not available in virtually any other field of law. When a lawsuit for copyright infringement is filed, most of the time, the plaintiff, in addition to seeking damages, is also going to ask the judge to, right at the beginning of the case, the day that the copyright infringement lawsuit is filed, the plaintiff is going to ask for the following, what lawyers call relief, for the following orders to be issued by the judge. 1, you shall stop selling, you shall stop exploiting the infringing work immediately. 2, all copies of the infringing work shall be seized by the United States Marshal and shall be held by the United States Marshal pending the resolution or the end of the lawsuit. That alone, the idea that you have to stop selling the infringing, the infringer has to stop selling the infringing work, and that the infringing copies will be seized by the United States Marshal, that alone will bring 99.99% of the defendants to the settlement table. If there is merit to the claim, if there is indeed provable access and provable substantial similarity, the defendant will never let the case get that far, because the defendant will have recognized that it faces the strong possibility of having the movie being released in the movie theater stopped, the book pulled from the shelves, whatever it is that the infringing work is, and all of the copies seized and all of the means of manufacturing those copies seized. The defendant will come running to the settlement table. If the defendant doesn't recognize the merits of the claim before it's filed, once those orders are issued, the defendant will come running to the settlement table 99.9% of the time. So that's why there are very few cases that you read about of copyright infringement. Now, on the other side, here in Hollywood, none of the motion picture studios have ever lost a claim for copyright infringement. None of the motion picture studios have ever, none of the television networks, none of the motion picture studios have ever successfully been sued for copyright infringement, because any meritorious claim gets quickly settled either before it's even filed, or if it's filed after the first day of its filing, which is why you rarely read about copyright infringement cases, and why you've never read about a motion picture studio losing a case for copyright infringement if it's gone all the way to trial. Okay, in the remaining time that I have, I want to talk briefly or somewhat about conveyance of copyright. How is the copyright in something that you've created conveyed to someone else? Or conversely, how do you acquire the copyright in something that somebody else has created for you? So if somebody, for example, has created an illustration that you want to incorporate into your book, how do you acquire that illustration? So copyright is conveyed in one of two ways. Either it is a work for hire, which means that you have employed the person who has created the drawing to use in your work, and therefore you are the owner of the copyright in that work because you have paid the person as your employee to create what you have created. So, as an example, every crew member, every actor, the director, the producers, everybody involved in the creation of a motion picture are employees of the studio or the production company that is making the movie, and therefore the production company or the studio or whatever it is owns the copyright in the results and proceeds, which is the way lawyers talk about it, of their services. That's how the copyright in their work is transferred or conveyed to the owner of the copyright, to the studio or the motion picture or the production company. The other way that a copyright can be transferred by one person to another is by a writing, a license, or an assignment. Assignment means you transfer the entire copyright for a sum of money. You pay me $100 for this drawing that you're going to incorporate for this drawing that I've created that you're going to incorporate in your book, and you own what I have created. I have assigned it to you. It must be in a writing. A writing in lawyer speak means something that is signed by both sides. Not just an email, not just a letter that's signed by you, but a writing, a contract that is signed by both parties, the assignor and the assignee. Or it can be a license. I hereby license to you the right to use my drawing in your book, and for each copy of the book that gets sold, you will pay me X dollars or X percent of what you make from the book, or whatever terms that you've agreed upon. So to talk about what Dwight asked me to talk about, which was graphics and conveyance of artwork. Here's the bottom line. If you want to acquire something created by somebody else, you need to have a writing, because you're not employing that somebody else. The first way that I talked about copyright being conveyed won't apply here. You're not employing people. You're not paying them workers' comp and unemployment insurance. You're not taking payroll taxes out. They're not operating under your supervision and control. They're not doing any of the things that create the employer-employee relationship. So the only other way that a copyright gets conveyed, as I said, is by some kind of a writing of an assignment or a license. A writing meaning a contract. So the bottom line is, if you want to acquire something created by somebody else, you need to have a contract with that person which specifies either that they're assigning the copyright to you in exchange for X dollars, or that they're licensing the copyright to you in exchange for whatever it is that you agree on. X dollars plus a percentage of each copy that gets sold, X dollars plus X dollars for each copy that gets sold. Whatever terms you agree upon are not important. What's important is that it be in a writing that both sides sign. So Dwight came to me sometime last month to talk about one of your members who had commissioned somebody to create something for her, but never nailed down the deal, never put it in writing, never agreed upon the terms under which the creator of the something conveyed it to one of your members. And she originally thought that there was, I forget exactly what she thought, but at the end of the day, my advice to her and my advice to all of you is, as I said, get it in writing, agree on the terms. That's the whole reason why you want things in writing, is so that there's no dispute later on. By the way, this is the same principle that applies if you collaborate with somebody else. If you and somebody else jointly write something together, you want an agreement with your collaborator to be in writing. So there's never, ever a dispute over who gets what when the work is wildly successful. And there's $1 million on the table, and your collaborator comes to you and says, oh, I thought our deal was 70-30. But you have it in writing that it's 50-50. As my wife always says, and my old law professor used to say, if it's not in writing, it doesn't exist. Another way lawyers talk about this is that oral contracts are not worth the paper they're printed on, or oral contracts are just as good as written contracts, except you got to prove them. Yes, Mike.
Mr. Levine, thank you again
Paul,
for being here with us
I get
today.
to call you Mike, you get to call me Paul.
Okay, Paul, thank you for being with us today. Can you check the chat? You have a question from the chat.
Oh, there's 7 chats here, okay. How strong is an email with permission to reprint an article, poem, or a photo into a newsletter that is viewed by the public on a website? Not strong at all. For all the reasons I said. The Copyright Act requires a writing. And a writing equals something that is signed. Now, Rusty, it can be signed electronically. Okay, you can use DocuSign. You can use Adobe Sign. You can use whatever electronic, at least here in California, I don't know about the 49 other states, California has recognized electronic signing. So a valid writing is one that is either signed in ink or signed electronically, but it needs to be signed. Now, if I represented you and you were, hang on, let me finish because it's not as bad as you think it is. If I represented you, I would argue that that email with the to and the from is the equivalent of an electronic signature. Depending on what the judge had for breakfast, depending on what the jury thinks of you and the other side, I may or may not prevail on that argument, but it's an argument. In order to have to prevent having even going there and having that argument, get the DocuSign, get the electronic signature. Make sense? Okay. Dwight, we lost you. While we're waiting for Dwight to return, any other questions that I can possibly answer on copyright or anything else that you think I might know about? Ah, there he is. Okay, Dwight, yes, go ahead.
Must the writing be notarized if the individual is out of state?
No, doesn't matter. Notarization is not important. The only time a writing has to be notarized is when it's recorded in the Copyright Office. So to show that that title is being conveyed. It, as we say in Yiddish, it couldn't hoit. You know, if you want to get it notarized, it's not a bad idea, especially, as I said, if you're going to record it in the Copyright Office. The Copyright Office has a system very similar to the County Recorder's Office for deeds and instruments involving real property, which must be notarized. The Copyright Office has a similar requirement. So if you think that someday you're going to want to record the assignment of copyright or the license of copyright, then you might want to have it notarized. But it's not necessary if it's just a private document between you and the creator of whatever it is that you're requiring.
Thank you.
Sure. Okay, Dwight, I'm going to bow out and you are back in.